I want to talk to Jon and thank you so much for your generous help in setting up the nonprofit association, which is the Greater Philadelphia Chinese Landlord Association. Most of the legal work has been done free of charge by Mr. Jon Taylor, helping us to register and as well as the paperwork soliciting all these meetings. And thank you so much for your help. Thank you. Greatly appreciate it.
And Alex, thank you for giving me the opportunity to be involved in such a great endeavor as the Greater Philadelphia Chinese Landlord Association. We need this association, and this association is going to do great work in the future in helping landlords learn about the landlord-tenant process and making landlords, be better at their business and help their families. So
yes,
thank you for giving me the opportunity to get involved. I mean, I look forward to seeing how it emerges. There's a lot of stuff that has to be done, and hopefully some of the participants in today's conference may show some interest in becoming members when we send out more information about that process, which will be sent out soon.
I think this is a wonderful group. Most of the members here in the WeChat group are Chinese, and we have two groups so far. The one group has reached the group member limit of 500. The other group is reaching to a member of 100. So total in WeChat group, we have about 600 members. They're all Chinese landlords, and Chinese love investing in the real estate. And the second characteristic is most of us prefer doing DIYs. But however, in the process of DIYs, we made so many mistakes and costing mistakes. Some of the mistakes can be easily avoided by seeking professional counsel, like attorney like you. I think this is I'm not against DIYs, but I'm strongly advise everybody to follow at least, doing the consultation, follow your attorney at least once and twice and 3 times before you're doing something on your own, because some of the easy mistakes can be easily avoided by your attorneys, which can cost you a lot of money. This is why we're holding seminars, letting Mr. Taylor to explain to us why this is so important. So, Jon, the floor is yours.
So what I'm going to do is I'm going to start the seminar, but I'll just start with an introduction. So hopefully if people come in the next 5 minutes, they're going to be able to hear the core information of the seminar. I'm just going to begin with a brief introduction of myself. I'm going to talk about the topic of today's seminar, and I'm also going to give a quick, just short preview of probably future seminars and future topics. So first of all, my name is Jon Taylor. I'm a lawyer. I've been practicing law since 2006. My background actually began in commercial banking, and I was a part of a bank in Northeast Philadelphia, and I was in their foreclosure and collections department. So I was doing a lot of foreclosures back in 2008 and between 2012, which was a really prevalent time in that industry. During that process, I actually did a lot of workouts, loan workouts. What is a loan workout? Well, let's say very often would actually foreclose on landlords who had trouble making their payments. And sometimes to avoid taking their properties, we would arrange deals. They were called workouts. They were negotiations to help these landlords, get back on their feet. Because 2008 was a unique time. It was an economic downturn. And, some of these people, we couldn't help them, but we were able to help a lot of them. And, eventually I got my own firm in 2012. And amazingly, some of the people who I had, foreclosed on actually became my clients. And I was surprised by this. And they said, the reason why is that was more reasonable than the other banks who were foreclosing at them. Because, at that time it was very often people had multiple problems. So that's really started my process in getting involved in the evictions. And evictions back in, 2010, 2012 were very, very different back then. It was advisable for a landlord to have an attorney, especially if a landlord had made errors, or the landlord had a very complicated case, or a landlord had a very, very difficult tenant. A lawyer was really very needed. However, in a lot of cases, if the landlord was, capable, the landlord could actually, do a lot of it themselves. They could figure it out. If mistakes were made, honest, easy mistakes, they could be corrected easily. And the judges and the courts were more sympathetic to landlords back then. I believe, and I say this respectfully to the judges, I know many judges and I respect many judges. And actually, many of the judges who used to practice back then in 2010, 2012 are no longer on the bench. But there was a more of a balanced approach. There was an understanding that landlords had bills to pay. There was an understanding that landlords paid taxes. There was an understanding that landlords, weren't necessarily evil. And as those days are are gone, the law now has become very, very rigid in an unequal way. How would I say that? The law today in landlord-tenant court, and I'm speaking of Philadelphia, by the way. I'm only speaking of Philadelphia. But the landlord-tenant law of Philadelphia is very different now than it was just, 10, 14 years ago. As I said before, the approach attempted to be more balanced. And now we have an approach where there's lots of local Philadelphia rules that are practiced very rigidly, very rigid against landlords, meaning that landlords have to follow everything to the letter. Tenants, however, do not. Tenants are given a broad discretion in terms of how they can act. And the courts give the tenants a very large lot of leeway. Before I go on, let me say this. I'm talking about residential leases. I'm talking about residential evictions. Commercial evictions, I will not discuss today. And they tend to, and because, ironically, a commercial eviction can be a lot easier than a residential eviction, which to me is ironic because usually a commercial eviction, there's a lot more money involved. But going back to what I was saying earlier, these statements are really referred to residential evictions. So now what I'm going to do is we've got into and let me say this, and after today's seminar, which is just going to focus on the initial application process to retain an attorney to start an eviction process. So today we're going to talk about the initial application process you will need, the documents you will need, the information you will need to give to your attorney to start an eviction in Philadelphia. Okay? By knowing this information, and knowing why you need this information, again, knowing why you need this information will tell you, or may give you information on stuff you must do now, even if you do not have a problem. Because you will find that if you don't have certain documents before the eviction process before you want to start an eviction, you may not be able to do an eviction because you don't have all the necessary paperwork. Now, I'm also going to explain to you why you need this paperwork. Now, as many of you may know, there's a process called the mediation process. Now, that mediation process, we're not going to discuss in depth today. Okay, that's going to be for the next seminar. And the third seminar will be about the eviction trial and complaint. And I think you're kind of seeing the pattern here. And the next one will be about the lockout process. But right now, today, we're just going to start showing what documents we need to start an eviction, a residential eviction in Philadelphia. Mr. Wong, can I share the screen, please? All right, so I'm going to share the screen quickly here. And I'm just checking the chat line It's in. Okay, so I just want to check the chat line. Does everyone see this list of items? It should begin to file an eviction. The following information is required.
I cannot see the share screen.
Okay, let me see. What can you see?
Just the Zoom. Right now we are sharing.
Okay, excellent. So, all right, so we're going to begin now. Some of this is going to sound very obvious because it is. So, actually, you see, I think you're seeing two screens now. Oops, I'm sorry. You're not seeing anything. You're seeing my fields. Okay. So to file an eviction, yes, we need to know the address of the property, the leasehold property. We need to know the correct address of the property. Okay. So the address of the property should be the same address on the lease. It should be the same address on the license and inspection rental license certificate. Okay. It should be that should be the same address. Okay. If the address on the lease says unit 2 and unit 3, and the license and your rental license says it's a single family, that could cause difficulties. Okay. And be aware. Okay. What should happen is your rental license, your L&I rental license address, and the address on the lease should be the same. Okay. Now, we also, to start the lease process, we need to know the name of the tenant, their phone number, and their email address. We should also know the name, any aliases of the tenant. So does the tenant have more than one name that they use? We should know this information, and that should be provided if you're able to do it. The other information is a copy of the lease. This should be self-explanatory. Most of you guys have leases that are written, but maybe some of you do not. And maybe some of you have heard that you cannot file an eviction unless you have a written license. Sorry, a written lease. And you have to go do something different, which is called an ejectment. And that is not true in Philadelphia. So you do not have to worry about that in Philadelphia. The city of Philadelphia, you can enforce an oral lease. Okay? Or you just have to, the issue is so difficult about oral lease, however, is the terms. Which means that when you have an oral lease, if there is a trial, your trial will take much longer and it will be much harder. Because you will have to tell the judge the terms of this oral lease. And that can be difficult if the tenant does not agree with your interpretation of the terms of the oral lease. And as a result, the judge will have to look at payment histories. The other problem with an oral lease is there's a lot of things, a lot of rights a lease will give you that you don't have under an oral lease. Now, if your lease is lost or stolen, that is okay. You just tell your attorney, and your attorney will tell the court. So we've gone through the first three things. We need the address of the property, which should be the same address on the L&I rental certificate. The name of the tenant. We should also know names that the tenant uses other than names on the lease. We should have a copy of the lease. If we don't have a copy and it's lost or stolen, it's not a problem. And if it's an oral in Philadelphia, we can still file the eviction. Okay, we need a copy of the L&I commercial activity license. Okay. If you don't have that, that's an issue. You have to get one. If you don't, because you will not be able to file your eviction. Now, if you don't have an L&I commercial activity license now, you should go to the PhilaGov website and start to obtain one. If you have difficulties, I actually, maybe talking to Mr. Wong would be a good idea because that is something, my firm doesn't do. It can be kind of time intensive, but you can get guidance through people like Mr. Wong, and there's other people who help people get their permits. And that is something you can discuss with him. So it's really a commercial activity license. And one of the things that you need to know is you can't file an eviction without it. So if you don't have one, get it now. There's other reasons why you need it, and I'll explain it later. But one of those reasons is you need an L&I rental license certificate. If you don't have that, you can't file an eviction. So you have to show that you have the L&I commercial activity license. Okay. You should also, before that, get what's called a lead certificate. Okay. That is only if the house you're renting was built before 1978. If you don't know if your house was built before 1978, the answer is it probably was if it's not a new construction. Okay. It probably was if it's not a new construction. Okay. And you probably know already. There was a time when you only needed one if there was children at the property. That is no longer the case. You need a license no matter where the property is. There was a time where it only applied to certain zip codes. Now it applies to all zip codes. So you need that lead certificate. Okay? It's very important. Now, one of the things you're also going to need to give us, and I'm going to talk a little bit, and here's the thing about the lead certificate, another thing, a little caveat about the lead certificate. You need a lead certificate for each new tenant. Okay? It's not like one all fix all. Okay? And also your rental certificate, your L&I rental certificate must be current. They have to be renewed. And they even have to be renewed during the eviction process. I'm going ahead of myself right now. I know I was going to say I wasn't going to talk about the eviction process, but I'm going to say a little bit now. The one thing about a license, and I always think this is fascinating. I don't like this at all, but your license has to be current at all times. Okay? So you can start an eviction, and then if your license expires before you go to court, you have to renew it. Okay? For most people, this is very easy, but you're not going to be able to renew your license if the city says you haven't paid your taxes and the city says there's code violations on the property. Okay? So that's something you have to really think about. Okay? So now you also have to provide to me a copy of a signed rental suitability certificate. It has to be signed. Okay? So that means when your tenant moves in, you have to go online, and if you need help with this, maybe you could contact Alex, but if you have to go on the internet and get a rental suitability certificate, print it out, mail it to your client, deliver it to your client, have your client sign it, and send that signed copy to me. Okay? And that's the same thing with the lead cert. The law says that the lead cert has to be signed by the tenant too. This is very confusing because some lead certs don't have a place for the tenant to sign, especially older ones. Generally speaking, that doesn't happen as much anymore, but the tenant's supposed to sign the lead cert confirming delivery. But again, this is hard because a lot of lead certs don't have that. Well, not a lot, some. So the answer is if there's no line for the tenant to sign, just have them sign it anyway. Okay? You have to provide to me outstanding utility bills. You don't need to do that, but if you want to make money and collect on that in the judgment, you got to give it to me. Or you're going to have to give it to me if the only reason you're evicting them is because the tenant's refusing to pay a water bill. Okay? Going back to the water bill, your tenant's not paying the water bill. Do you have to pay the water bill for them? Yeah, you can't let them lose their water. It's just the way it is. But the thing about the utility bills is that if you want to collect on the utility bills And if you want to, or just evict them only for the utility bills, then you have to give me those documents. I'm finding now that I'm doing a lot more evictions for Section 8. We're not going to talk a lot about Section 8 today. That's going to be another seminar. And Section 8 is a very fascinating topic for my larger landlords who own like 20, 30 units, and they're usually spread out across the city. A lot of those larger clients are moving into Section 8. A lot of my larger clients are moving into Section 8. And it is a totally different beast, how the eviction process works. The trial strategy is totally different. One thing about Section 8 tenants I've noticed is that they are almost always provided free counsel during the eviction process, almost always, which means the eviction trials take longer. The other thing about the reason why I was thinking about Section 8 right now, though, was the utility bill issue. A lot of my landlords will get in Section 8, they'll be paid the rent. They'll get all their rent from the government, but the tenant won't pay the utility bill. So I'm actually having a lot more cases where the landlords are not evicting based on unpaid rent, but unpaid utilities. Because I'm not sure why this is. Maybe it's because the Section 8 tenants just don't have a lot of money. So even in a situation where they don't pay any rent, or they pay maybe, you have Section 8 tenants who might pay $25 a month for rent. So even though they may only pay $25 of money a month for rent, they still don't have enough money to pay for the utilities. And for that reason, I just have a lot more cases where that's why we're evicting people, not paying utility bills. And that's a change, I think, since the COVID. That's become a change. We still want verification of any children under the age of 6. That is no longer as important as it used to be. I know that sounds strange. It used to be you needed a lead license only when the kids were under 6 years old, and that's why we had to ask that question. And, if then we'd have a big issue with lead certs. That's not as important to us anymore as it used to be. We like to know that information just to know it, really, but it's not as important to me anymore as it used to be. I mean, if you do have small children at the unit, yes, you're more likely to get a free lawyer. And I say a free lawyer, those are lawyers from what's called the community legal services. And yeah, if there's children at the property, you might be more likely, but it's not because of children. It's only because, of wage issues. The larger the family, the less the money, the more likely they get a free lawyer. But that's really not as important question anymore. This is an important question to us, and it's number 10. It's the payment log. And it would be one of the things is a lot of times payment records aren't as good as they should be. And this is really kind of a difference. My larger clients, my payment logs are pretty good. Payment logs are not that difficult. But we ask all the clients, no longer their size, but especially kind of a smaller client, they have a trouble time with this sometimes. And what we do is we send them a ledger, and even if they have their own ledgers, we ask them to fill out ours, okay? Because this is all we need to know. We need to know the charge and the date, the amount due, the amount paid, and the balance, okay? And just filling this out is kind of enough. So, if we need to know the rent, let's see, January 2025. $1,000. Email paid. Say it was like 500. I think we know the math here, guys, don't we? 500. Then we got utilities. I'll put Pico. We just need to know these information, and we need to know like a backup. Okay. So for the Pico thing, you're gonna have to send us a copy of the bill. Okay. It's really not that hard to do this, but a lot of people just have a hard time doing it. Okay. But it will make things a lot easier because, you know, we can then file this more quickly. If you don't really give us this information, it can delay, the filing of the landlord-tenant complaint. And, this is an issue, especially is going to be important during trial that, because a lot of times there's arguments about money, about what was paid and what was not paid. And just having this information available is just really, really, really useful to start the eviction process. So once you've given me like all this information and you've retained the counsel, the next thing we do is we take the information you've given us and we provide information for the eviction diversion program, and we submit a application to the eviction diversion program, and we start that process because we can't do any eviction for 30 days. So we do that. But during the next phase, what we do is, what I want to talk about is, once you've given me all these documents, what are you going to do, for example, let's say you never delivered these documents. Let's say that you had a rental license certificate, but you never delivered it to the tenant. You had a lead certificate, but you never gave it to the tenant. You have no idea what a rental suitability certificate, so you didn't do it. Well, what we do for you, though, is once you get us those documents, we deliver them for you. We mail them out to the tenant, and we start the process. And I want to say something that's going to be kind of interesting. Let's say you did this stuff already. Let's say you did it already, and you've always done it. We'll do it for you again. And there's a reason why we do that. Because I've had cases, well, not anymore, because it doesn't happen anymore, but I had a case where we had a landlord tell us, and I think the landlord really believed it. The landlord wasn't lying. The landlord wasn't lying. I don't think so. But what happened was, like, he said that he had delivered the rental suitability certificate, right? But the problem was, when we had the trial, he said he didn't, okay? And because he just made a mistake, okay? And we lost the trial. We had to do everything all over again. Because, we thought we didn't have to do it because he said he said he did it. So now what we do, even though we know the landlord does it, we do it anyway. Because that way, because let me explain why. Let's say we go to trial and the landlord says, "Oh, I never really did it. It was a mistake. I didn't mean to say that." Well, it doesn't matter so much anymore because the firm has already done it. It means the landlord's going to get less money on the judgment, but we've already delivered it. So we say to the judge, the issue is it's already been done earlier by us, the firm. So we no longer have to worry about a miscommunication between us and the client. We don't have to worry about the landlord forgetting that he didn't do something, because we do it for them again. And that way you go to the trial. Well, that way you don't have to worry about the trial, okay, as much, because you've got your ducks in a row. You're ready, and you've delivered you've done more than you have to do. Okay. So another thing, and this isn't on the list, by the way, because nobody does it. Nobody does it. It's called the bed bug book. Okay. Whenever in Philadelphia you get a new tenant, you have to give them a bed bug information pamphlet. Okay. And the law says you can't file an eviction unless you do this. Okay. That's what the law says. I have never had a judge tell me I couldn't do an eviction because I didn't show the bed bug book. I've never lost a case because of the bed bug book. And not only that, there was nothing, most practitioners do not give the bed bug book out because the courts don't enforce it. Not only do the courts do not enforce it, for whatever reason, the other landlord-tenant lawyers don't really focus on it. We do it anyway, because the issue is that one day the bed bug book would be enforced, okay? And that's why we do it. And I want to go back to the rental lead certificate. I scared you guys maybe about the lead certificate not being signed. Well, that's a hit or miss one, by the way. Some judges focus on it, some don't. The lead certificate not being signed is supposed to be signed, but I think because of the confusion that's been caused by some lead certificates not having a place really for tenants to sign, it's not really focused on as much. But we try to be like cautious and conservative and focus on things that, you know, that could become a problem in the future. And if they don't really lose you time. I mean, and one of the things you know about, you know, sending out the bed bug book, it's an easy thing for us to do for you. And you know, that's what we do. So that's just the, so right now we've just basically started the application process. And also what we do is we send out a notice to vacate for you too. Okay, so the notice to vacate, very often landlords will send notice to vacates themselves. That's fine. That's great. And we keep that on the record. But we as a firm, we send another notice to vacate out. And why do we do that? Because a notice to vacate has to have certain elements to it. And we don't want there to be any confusion. And another problem at a trial, that a landlord's notice to vacate was missing something. And so we sent out a notice to vacate as well. Okay. The other reason why we send a notice to vacate is that we read the leases and we make sure that the landlord included everything he could possibly evict the tenant for. Because we have certain situations where a landlord and a tenant just do not get along. And the landlord really doesn't care if they get all their money back. But so even if they want to try to evict the tenant for other reasons, okay? And that's why it's important to know those other reasons. Because, you know, the landlord might not care he gets his $1,000 back, his $2,000 back. He really wants this person out. So we read the lease and we find out other reasons to evict the tenant. And one of these reasons actually increasingly is becoming violence at units, especially for our larger apartment buildings. One of the things, you know, you should tell us is if there's any violence at the unit, and do you have movie cameras? I think that's very important, because sometimes if you can show violence, you can skip the mediation process and go right to court. It's called the danger exception. So, you know, we don't really ask for this right now, but that could change. This checklist list could change in the future, where we ask, you know, do you have video footage of violent activity? Do you have video footage of drug activity? Because what we're finding, especially for our larger units, is that tenants are moving out of larger units because other tenants are so bad. And this is a horrible situation for a landlord, because they have a bad tenant, and it's a triplex. They have a bad tenant and two other tenants are leaving the property because of the one bad tenant. And they can't pay their mortgage and they can't pay their taxes because it's one bad tenant. And that bad tenant might be paying their rent. That bad tenant might be paying their utilities. And this is kind of where Section 8 becomes an issue, because this is kind of a Section 8 thing we notice a lot more. We've got to find other reasons to evict these people, and it's nuisance. And what we're finding is the nuisance is tough, because we try to make the danger exception for nuisance to be really broad, but we're finding that doesn't always work. So we found that, you know, a tenant bothering another tenant, they're still focused to do mediation. A videotape of a gun, we skip mediation. We got a case right now where we got a tenant beating up a neighbor, and we're kind of having a hard time getting that one to skip mediation, which to me is surprising. we're actually, that's something we're working on. That's something we have to work on because we tried to apply for that and it was rejected. We told the court, the prothonotary, the court clerk, that we have video footage of a tenant beating a neighbor because the tenant's paying their bills, they're paying everything. The only reason is the tenant beat up a neighbor, and we have video footage of it, and the landlord just wants him out. And we're having trouble skipping mediation because of that, which is kind of a surprise to me. We may actually just go to the court ourselves, because with the filing unit, and just show the video, see if that may be enough. But that to me is a surprise that we can't skip mediation right away because a tenant is beating up a neighbor. To me, it's pretty easy and self-explanatory. But I think that kind of shows the difficulties we have in the city of Philadelphia with the rental process. And for example, why like the rules are so strictly enforced against landlords, but they're not strictly enforced against tenants. And and when we try to make exceptions, they make it very hard for landlords to get exceptions, whereas with tenants, they'll give anything for an exception. I'm going to just digress against a little bit again about this. One thing I have noticed is that when I started practicing, back in 2006, that we all know the security deposit law, and you can get like treble, trying to recall if it's double or treble damages. But if you don't return the security deposit in time, you have to pay the double the security amount. And usually, if a landlord was a day late or a week late, and there was an okay explanation, and the landlord wasn't a bad guy, you never had to worry about that. You just didn't have to worry about it. I am now finding that in my security deposit cases, that if the landlord's like a day late, just because, that the judges are just like, doubling the damages. I mean, that is the law. I understand that. That is the law. But it was usually when, the landlord was really nasty or really bad. Landlord made a big mistake. Landlord was very heartless. And that wasn't the law. That's just what the courts did. Now they're really strictly enforcing that. And that's the whole thing about it. These cases are just not equal. They for the tenants, they'll be very broad and give a lot of exceptions to the rule. But for your landlords, there's not as many exceptions to the rule. And when you want to make an exception to the rule, like skipping the mediation process because a tenant is beating up a neighbor, it gets kind of hard to get that through, where it doesn't make sense. I mean, it should easily go through. Or the idea that a tenant is being hostile to other tenants in the building to the extent that a tenant has moved out, that's not an exception to skip the mediation process. I mean, the worst part right now is what may have to happen, because law changes, and right now, we don't go to the judge and ask for an exception to the mediation program, because we have to first file the LT complaint. And you can't file it until you've gone through the mediation program. Okay. Well, so we're not even at this point trying to convince judges. We're trying to convince court workers, court personnel, prothonotaries, court clerks. They're not judges, they're not lawyers. Those are the people we are convincing at this stage to try to skip the mediation process. Now, I think hopefully courts will change and they're going to give us an opportunity to go directly to judges. And we're not quite there yet. Again, this mediation process is something that began during the COVID, but law and the courts must change, and they have to be flexible, because the law can't keep up with the world. The world creates problems that exceptions must be made so that the law can create justice. And that's why we have judges. And right now, the reason why, and this is part of the point of today's class, is the law will not really give exceptions to landlords. The law will not give exceptions to landlords. So the landlord now must follow these rules to the letter, because they were not even going to get their day in court unless they show they've gotten these application processes done, which is really surprising, because in higher courts, that you can get equity arguments to get yourself in front of a judge to explain why you don't need this paperwork. But it's not really, that doesn't really work in the lower court for the eviction court. So I think, the checklist here just shows these are the first items you need. And I think what we'll do is we'll open up for questions about, you may have like, why you need these documents, how can you get these documents? Unfortunately, I can't really show them to you because then I'd give out client information, but I can kind of like describe them to you and when they're needed and stuff. So if you have any questions, I'm definitely open. If the floor is definitely open. Let me stop the share.
Well, John, thank you so much for the wonderful, wonderful information. The information you provide is super valuable to us, and we appreciate that very much. I personally have a few questions. Number one, we have some landlords in the group. Their properties are owned under LLC, not under individual name. If we filed it under LLC's name, is there any additional documents that you would need besides the information you have presented?
I don't, as your attorney, I do not. I believe that if you file it yourself, though, you need to show a person who, a landlord who is by themselves filing an eviction. I believe they need to show an operating agreement and other documents proving that they're part of the company. I don't. Okay, I can just take a company and just file it. So there are additional requirements if you file it yourself, but I don't need to follow them. And that's
Okay. So
right.
all the landlord needs to know is when they inform you the property is owned under LLC, it will be fine.
Yeah, that's the thing. And it should, so the license, the commercial activity license and the rental suitability certificate license should reflect that. Okay.
Okay.
Now the lease should reflect that too. Now, if you if you got a situation where that's another issue. If the lease owner and the owner on the landlord on the lease should be the owner of the property. So sometimes you have to deal with that through an assignment or an agency relationship, but that's a different topic.
Okay. The second question we have is we have some discrepancies in the argument is the eviction diversion program is the same as the mediation process.
Yeah, I should be more clear. Okay, so the eviction diversion is the mediation program. Okay, and it's done over the phone. It's not done in person. And what happens is there's a mediator who's a volunteer. There is you, the landlord. I would be there. There is the tenant, and then there's a housing counselor. And sometimes there's the housing counselor's boss, or senior supervisor. But yeah, the mediation, when I say mediation program, I mean eviction diversion program. Correct.
Okay. And we have some landlord asking, how do you start with the mediation program or the eviction diversion program?
Once you provide us the information on that checklist, we send out a notice of eviction rights to the tenant, and on the same day, we apply to the eviction diversion program for the landlord, and we get it scheduled. Now, when we say get it scheduled, we get a confirmation about when it will happen, and then hopefully 2 or 3 days before, and not the day of, we'll get the telephone link. Usually it's 2 days before. Sometimes it's the day of, but we always know when, but we don't always have the link. We don't always have the telephone number and also the passcode to get in. And, in most cases, the landlord and the firm finds out at the same day. Some landlords just want us to be on the contact line because they don't, so then we'd have to tell the landlord. But yeah, that's how that process works.
Okay, we had another question came in on the private WeChat regarding the rent escrow during and after the eviction diversion program is being used.
Huh. What do you
Uh,
mean? You mean the deposit? You mean the tenant's escrow account when they're supposed to put money?
correct,
Oh,
correct.
yeah. Okay. So what's supposed to happen is that if a tenant is not paying the landlord rent because the tenant says that there's something wrong with the property, maybe there's no heat or there's not whatever, the tenant is supposed to put the money in an escrow account. That escrow account, it used to be banks used to allow to create these escrow accounts. Now they don't really do it, but it's supposed to be put into an individual account set up for that purpose. Okay. And the tenants are supposed to do that, but they don't. Okay. They just don't, because in most cases, tenants don't do it because the reason why they're not paying rent is because they just don't have the money. Okay. And even if they're saying it's because of other reasons, it may be because of reasons like heat and a broken stair and a broken railing. But it's also because they don't have the money. And as a result, there's really no escrow account to speak of. If you get to a trial. So when we go to mediation, they may ask about, is there an escrow account? And it's an off the cuff. It's a quick question because they know there's probably not. So the escrow account, if you're thinking, oh, there's going to be no mediation unless there's an escrow account, I know that wasn't your question, but there's going to be a mediation no matter what. They're just going to have a mediation because the escrow account is something that if a tenant has a real escrow account, that usually means the landlord has really done something wrong, because I have found, because that means the tenant really does have the money and is choosing not to pay and put stuff in an escrow account. But it is just so rare. It is just so rare for that to happen. I mean, yeah. So I don't know
Uh,
if that was the question about the escrow account, or
yes, yes, and also it wants to know if there's any 60 days of the delay after they use the eviction diversion program because
no, the 60 delay is a different concept, and we're going to talk about it in a different class about, do you take money from the government? If you got a tenant who owes something like 3,500 or less, you can take government funds, bring the guy current, but then you're going to have a delay in when you can evict. Okay, so that's really, I think, what you're thinking about the 60.
yes, yes.
We're going to talk about that later. Section 8 guys do it a lot, and they actually do it, for them, that's the best way to cure their little. My Section 8 guys do it a lot, especially
Okay.
utilities that aren't paid. Now, the funny thing, I'm going to digress here because this is something that I do not quite understand. And I'm not saying it because it's all right. This is very fascinating to me. Okay. The point of the money for this city money was to keep people in their homes. Okay. But there's actually, I'm not sure. Sometimes you're hearing it like there's ideas that you can get the money and the person can voluntarily leave. Okay. I think that's a very odd way of using the program, but I'm seeing it happen. Okay. They'll get money, but then they'll voluntarily leave. And I'm not quite sure if, why that's being allowed, because the purpose of the of the program was to keep people in their homes. But that's like another topic. But no, the 60 days, if you don't, so when you do the mediation, I digress. Let me go back. When you do the mediation, once it's done and you get your EVP number, you can schedule your court hearing. Okay. So after the mediation, one thing that's very frustrating about mediation or EVP program, the eviction diversion program, is sometimes you'll get you'll get your email saying that the eviction diversion program process is done, and you'll get that really fast. Other times it might take a week, it might take 10 days. And this is a crucial problem with that program. Okay. I mean, it's just a crucial. I had one that took about 2 weeks, and there's no explanation for why it happened. We We emailed them over and over again, them being the EVP. We emailed them and we weren't getting a response. And, that is a very bad thing about that program. The other bad thing about the program, as I digress, is you can make an agreement and it's supposed to be in writing, and they can take a while to get those back to you. They can take a while to get those back. You don't get those back the next day. You might not get them back for 3 days. Or if it was on a Friday, you might not get it back until like almost a week later. It is a really bad part about the program because there might be arguments about the terms because you don't write it there and then. Basically, you tell a mediator and he or she writes down what he or she remembers. So you can get a circumstance where you wait like a week for an agreement that comes out and it wasn't what you agreed to. And that's a rough thing. It's just because a week has already gone by and you got this agreement that isn't even correct. And, it's just a problem with the program. So anyway, I kind of, again, I digress. Any other question?
Yes, I have another question coming in from WeChat on private message. Is what happened to the case or any help from the attorneys with the eviction case when the tenants calls the LNI immediately when they receive an eviction notice from the court?
So if you get a notice from the court, you're okay. The problem is when they call LNI and you haven't filed an eviction with the court yet. Okay, that's where the problem happens. If they've called LNI and you've already started the court process, you just move forward with it. Sometimes, but if they do call LNI, then you can have a big problem. And the worst problem is if they call LNI before you get your commercial activity license and your other licenses in order. Because then if you have code violations, you can't get your licenses, which means why you should do it now. You should get these licenses when everything is good. And sorry about that.
John, I have a question.
Sure.
I know you talk mostly about Philly. Do you have experience near like Lehigh County or some other counties nearby? Is it similar as bad as Philly?
No. I have no. You know what? I am going to make a crazy statement. I have no experience in Lehigh County, but I'm actually 100% sure it's not as bad as here. But I have no experience in Lehigh. It's yeah, that's why you gotta be careful when if you go on the internet, always say Philadelphia eviction because you go Pennsylvania eviction, it's just not gonna. You're gonna be wondering why it takes so long. It's this is all Philadelphia information, and the other thing about these licenses though too is so when you get your things change all the time. So before you get your when you give people like rental suitability certificates or when you give people the partnership for good housing pamphlet, which I forgot to tell about, you got to give them that pamphlet. You got to go online and get the new one because it could always change. Usually they change a little bit every year, but you always have to make sure you got the most current bed bug book, the most current partnership for good housing book. And so before you get things to a new tenant, always make sure it's up to date and current. So, and because that's actually what we do. We don't keep we don't keep one on file. Whenever we get a new file, we just download what's off the website because we don't have to be worried about sending something old or stale. We make sure that it's the most current thing because sometimes they usually change them on a yearly basis. So that's one of the things you got to really think about. You can't just keep sending out the same documents, every year because it's going to change and the information on it's going to change.
Thank you. A follow-up question on your talking about the mediation process or the what do you call it, diversion? I'm not familiar with that. Is that so? In terms of the whole eviction process, does it mean like before we actually evict or get to the sheriff evicting process, we go through this mediation or diversion process? What?
It used to, all right, I'll explain what it was like before the eviction diversion program to give you an idea how the eviction diversion program makes things different. You would hire me, you'd get me the documents, I'd file the eviction. Okay, which means I could get that eviction filed within 24 hours if I got all the documents. I mean, it could be like, boom. Now, you give me the documents. I have the information for the eviction diversion program. I file the eviction diversion program. I don't file the complaint. You don't have a court date yet. You do not have a court date. Now, I'm not going to be able to get you a court date until after the eviction diversion program period of time is over, which should be 30 days. But it's more than 30 days. The reason why it's more than 30 days is because I have to wait for the eviction diversion program to send me an email saying that the 30 days is up. So you're talking 33 days, you're talking 34 days, you're talking 40 days. 40 is an exception. That's weird. But you're talking like 31 days, 32 days. I get that information and then I file the eviction. Okay? And that means you've lost a month. A month. And that's what's so bad about the program. So imagine you got the person with the gun, we got the person with the tenant who beat up the neighbor. We got to wait a month before we go to court. I mean, it is insane how that works. And what they should do, I mean, it would be good if they could allow us to file the complaint, do the eviction program, and then if the eviction program, the eviction diversion program, and if the eviction diversion program doesn't work, at least we have a court date. So we don't lose a month. But that's not how it works. So yeah. Because what's horrible about it is a landlord doesn't call me right away. A landlord calls me after they've had 10 phone calls with the tenant, 100 text messages with the tenant, 100 emails with the tenant. They've had face-to-face contact with the tenant. Then the landlord calls me, okay? So that's the whole problem with the eviction diversion program. They're acting like landlords are going right to court right away. But no, landlords are trying to not hire me, okay? Landlords are trying to do this without me. And so they've already been doing this stuff for like a month already, okay? Maybe 2 months. And then what's crazy is after they were, after the landlord is trying to be a good person and solve the problem without a lawyer for 2 months, they hire me and I tell them they have to wait another month. It is insane. And this is actually the big surprise between the irony is, and this is the irony, I think a lot of landlords are just not spending as much time trying to fix problems themselves because they know about the diversion program. They know that if they wait too long, they're going to have to end up waiting even more. So instead of trying to solve the problem by themselves, some of my guys just go right to me right away. And it's because of the eviction diversion program. I think it can kind of, I know a lot of people say it does work very well and stuff like that, but I think it can cause like an unnecessary delay. I think landlords should be allowed to file at the beginning of the 30 days so they don't lose time. And I think they should also have clear exceptions for landlords to file and just skip it when a tenant is being hostile, aggressive, and mean. So, any other questions?
My follow-up question is following up with Sherry's question. Is the eviction diversion program, is it only required in Philadelphia County?
I don't know that. That's a great question. I don't know the answer to that question. I believe I believe it's a Philadelphia program, and I believe that most counties don't have it. But I do not know if there's other counties in Pennsylvania that have it. I've never been told by other lawyers that they have to do this in Monco. I've never been told by other lawyers if they have to do this in Delaware County. And yeah, I don't have an answer to that question. But I can say I've never heard of a diversion program in other places. I know Philadelphia's diversion program is pretty famous across the country. Because a lot of people support these kind of programs, and Philadelphia was one of the first to do it, and it was as a result of the COVID.
Do you ever see this the eviction diversion program going to end anytime soon?
You know, the only way it would, I don't know. The only way it would end is if government stopped funding it, because you know, a lot of the people involved are volunteers, but it does require government funding. And if the government stopped funding it, it would go away. But I've not heard of it. I don't think it's going to go away anytime soon. I think it's going to always be there. I think what with advocacy groups, and I think this is actually where the Chinese, Greater Philadelphia Chinese Landlord Association could actually do something. If groups of landlords got together, I don't believe it's feasible to get rid of the diversion program, but I believe it's feasible. I believe it's possible to make it so that we don't have to go through the diversion program when we have tenants who are violent. And one of the things here's the things. Every landlord should have a camera on the door. Every landlord should have a camera in the hallway, okay, of their units, especially if they have a duplex or a triplex. And the consequence is that you're going to find out things about your tenants you never even know. Very frightening things about people. And you're going to, if you've got properties in neighborhoods with a great deal of crime, you're going to see guns and stuff. And I think the groups, you know, like the Greater Philadelphia Chinese Landlord Association, if they got politicians to say, listen, give us the right to just skip this diversion program and go right to court when we've got a dangerous tenant. And that needs to be put in the law, because, I mean, once you, the landlord, know that a tenant is dangerous, you got to be kidding. You could be on the hook for not trying. So for a dog case, for example, this would be another class, dogs, landlords. If you as a landlord know that a dog of your tenant is violent and vicious and nasty and mean, you could be sued if that dog bites somebody, okay? If you, the landlord, know that the dog is dangerous, all right? And one of the things that could protect you is if you evict the tenant because they have because they have a dog. So let's say that, like, you start an eviction because you know this dog is dangerous and mean and nasty, and then the dog bites a small child. A great defense is, Your Honor, I'm the landlord. I am not responsible for this dog biting this child because I did an eviction. I did everything I could to get this guy out of the building. And here's the evidence. There's nothing more I could do. I couldn't. And that's why, you know, that's one of the things you got to think about when you do these evictions. You sometimes kind of have to do an eviction when you know your tenant is being dangerous and a criminal. Because if you don't start the eviction program, you could get sued for something if that tenant does something really, really bad. Okay. And for dog cases, it's very, very clear. For tenants beating up neighbors, nah, it's not. I think you're going to be okay. I don't think you're going to be sued for that. All right. But you don't want that to happen. Okay. So, and that's one of the and that's the problem with the eviction diversion program. It causes delays really that are causing danger to the community. And they need to change that. So I don't think the diversion program will not go away. That is my opinion. I think government's going to fund it, but I think it needs to be changed so that landlords can skip it.
I think you just mentioned a very, very valid point because most of my discussions with my landlords, when they wish to file evictions are when tenants failing to pay rent. I think there's another big thing, the risk is when certain actions of the tenants causing additional liabilities to the landlord. This is also a reason why we file evictions, not just for the money, but also to protect one of your most valuable asset, your real estate.
Yeah.
Yeah.
Well, that's the thing.
So,
Yeah, and the thing is that when you get those cameras in, you start seeing stuff, and you're realizing. I mean, when you see them damaging the hallways, you see them fighting people, and you just have to find out. You have to respond to that. I mean, because it can lead to other problems. Um, yeah, it leads to terrible things.
well, allow me for 2 seconds. I'm gonna ask anybody in the group and also in this in Chinese to see if they have any additional questions. 咱们这个群里面还有其他的朋友，有没有什么问题没有？如果有的话呢，我可以在这边问一下律师。
Hello, John.
OK，如果您这边有问题的话，您可以讲，请讲。
Hello, John. Yeah, this is Peter. How are you?
Hey, I'm doing pretty good.
Yeah, I think your section is pretty important, very valuable. And I have a friend that a couple of days ago, they called me. They purchased a house in Philadelphia. That's new construction. The 10 years abandoned, they're waiting for the 10 years abandoned. It's not being approved, but the house was rented. And during the time, the tenant did not pay, the for the rent. So they asked me, and finally they got it. A couple weeks ago they got it, the rental license right now. What he can do, because they do have like a certain period of time don't have a rental license, but they did apply, just not get approved because they did not pay the tax.
So I didn't hear all your questions because there was some static, but you cannot file the eviction without the
Rental license.
rental license. But
Yeah, they do have.
What also makes it very, very frustrating is that you can only collect rent for the period of time you have an active rental license.
Okay, I got you.
And that is a horrible situation.
Right.
When a landlord comes to you and says, I am owed $10,000. And you
Right.
say, well, where's your rental license?
Okay.
Oh, now most of them get it at this point, but the issue is you can only collect money for the time you got your rental license. So if you get your rental license, if you were not paid any money in 2024, you got zero rent, and you will come to me, and it's February 2nd, and they're saying, can I get rent for February 2024 in this January? And you have a license, rental license? No, we have to get you a rental license. Now, in cases like that, what does happen is they don't pay February, they don't pay March. So we've done mediation, and by the time we get to court, they owe 2 months of rent. Okay. I got a lot of cases where I'm only collecting 2 months of rent for people who owe months and months and months of rent. Now, one of the problems is, though, if we're only suing those people for non-payment, they can actually pay everything up, and you have to let them live there. That rarely happens. I'm going to tell you one story, though. This was kind of it wasn't really a funny story, but I once had we were trying to evict somebody for non-payment of rent, and they owed $5,000, $6,000. They owed thousands of dollars, and we won the trial. And then it was just for non-payment of rent, because that was the only reason we were really given. So what happens is we win the trial in front of Judge Washington, and the tenant just brings out a stack of $100 bills. And he paid thousands of dollars of rent in the courtroom in front of the judge. And, you know, we then had to satisfy the judgment, and, you know, case was over. The guy got to stay. I think the way that did end, eventually he did leave. He left shortly after that period of time. He did leave. But that was a case where we won the trial and we were paid in front of the judge. The judgment was paid in front of the judge. I want to say something though. Most cases, for landlord-tenant cases, money judgments, you never get paid. Okay, you don't get the money back. All right, and that was just kind of an illustration of a story. But yeah, you've got to get that's why you got to get your licenses in order, because you're not going to be able to collect unpaid rent for periods of time you don't have an active license. And even this is crazy. This is crazy. Let's say your license expires. Your license expires, and for like 2 weeks, you don't have an active license. Then you get an active license. Well, what happens is you get all the money up to the date the license expired, and you can't collect the rent for that period of time you had no license, but you can start collecting rent again. So sometimes you have this doesn't happen as much anymore, but sometimes you'll have a gap period, and we have to like calculate the gap period when you can't. It's just it's ridiculous. It is absolutely ridiculous. But yeah, so that explains the importance of all that stuff. So I hope I answered your question.
John, I have a kind of silly question. Like, you know, these tenants don't pay for like, you know, $6,000, they get evicted, but there's a judgment against them on the book, right? Do they eventually pay? Because otherwise it's there forever. Or what do you think? Most of them just never pay.
I will tell you. So let me tell you some information. I will tell you that I'm going to tell you that most tenants, the vast majority of tenants, over 90%, over 95%, never pay the money. Okay. So let me just say the circumstances you can get paid back.
No.
So I honestly do not know how many evictions I've done at this point. I don't know. It's either I'm in like the high hundreds or the low thousands. I don't know anymore. I got to figure this out. But I once got a call from a very nice lady, and she said she owed my client like $3,000. I had no idea who she was. No idea who this person was. And I said, are you sure? And she said, yeah, I evicted her. I still did not know who she was. So I asked for the LT number. The LT number is the case ID number. She gave me the case ID number, and I still didn't remember her, but I knew the client very well. And yes, I had evicted her. And I said, well, what would you like to do? And she says, I want to pay the judgment. Great. So let me call my client. Call my client. Of course, she wanted to be paid. She came to my office, and I asked, thank you. She gave me the check, and I asked, why are you doing this? I mean, it's great that you're paying this money. And she said she had to buy a house, and this came up, and it was making it hard for her to buy a house. So she paid. Okay. That almost never happens. Okay. The only way you're really the way you're probably going to get paid, and we'll talk about this during the trial class, is you can negotiate what's called a judgment by agreement, and people pay off the judgment during the judgment by agreement or a little bit off, but even that doesn't happen very often. Okay. When you get a judgment, you can go after their bank accounts, but that doesn't happen very often because they don't have money in a lot of these tenants don't have money in their bank accounts. But the other thing that's happened is a lot of landlords don't know the bank account information of the tenant because tenants don't pay with checks anymore. It used to be we knew where a tenant banked because we had all these checks. Now they're being paid by Venmo or Zelle or whatever. We don't know where they bank. And I mean, landlords should probably get bank account information and put it in the application or something like that. And that would be kind of helpful, I think, to do that. Now, if you do a judgment by agreement, though, you can also garnish wages. We're doing that right now with somebody. And the reason why we're doing it right now for somebody is we actually have somebody, really weird case, a tenant with a very good job. And, we've started the garnishment process for that. But that's an exception to the rule because most residential tenants just don't have that much money. And you really just don't really collect them. Now, it's not, with a commercial case, it's usually different. But for the residential case, you really shouldn't expect to get the money. You really just want to get them out. Okay? You want to get them out. And if you get the money, you should feel very fortunate that you got something. Okay? And that's actually why you have to evict people fast so they don't owe you $10,000. Okay? You want to evict people fast so they don't owe you $10,000. Okay? Because, anybody who lets that debt get that high really doesn't have the money. I don't believe it's because they're bad and they're trying not to pay you. I really believe most of them just don't have the money to pay you. And you're not going to get them. They're not going to ever be able to afford to pay you back. So.
Here's a question from the note section. Is from April. It says, if the tenant has always paid rent late and she always paid, there is a late fee due to the landlord. And can the landlord get the late fees from the eviction program?
I've never seen that. I think it could be possible, especially if the late fees are below $3,500. I've never seen that. I will say something, though, that you should know for trial, though. A Philadelphia judge will almost 95% of the time not award late fees. Okay? Some judges tell you straight up they will not give you a late fee. Okay? And a lot of judges will take the late fees out of a judgment. Okay? And you also have to be careful about your late fees. Your late fees have to be reasonable. Okay? A late fee of $50 could be reasonable. $25 is very reasonable. Once you get over $100 late fees or $150 late fees, a lot of landlords just won't award those. A lot of judges won't award those. So you have to think about that. So I've never saw that where someone was sent to the eviction diversion program and just to collect late fees. I've never seen that. But I think it could work if it was under 3,500. I'd have to research that topic, but I also don't know if it's really worth your time and effort to do that. How much can I ask in your hypothetical? I know this isn't, I'm not asking a private question, but how much late fees are you thinking here? How much in late fees are you thinking?
Actually, that question came from me.
Yeah.
The person actually signed like a weekly lease with me, so every week she's paying late. So that was since like 2 years ago. There's quite a bit late fees.
That's interesting. That
Yes.
is interesting. You got a lease where someone pays every week. Wow.
Yes, every week.
Huh. All right,
For example,
ask any more questions. I don't have any more questions. That's interesting. We can talk later about that. Okay, but that's fascinating. Okay, yeah, that's an interesting idea. Okay, does anyone else have any other questions?
I don't have any questions coming out from the WeChat.其他各位朋友还有什么其他问题没有？
Hey, John, I had one more question about the judgment. How
Sure.
many years with judgment will be stay? I heard the 5 year was expired.
Okay, so
True.
it's a little bit different than that. It's the judgment has to be revived every 5 years. Okay, and if the judgment is not revived every 5 years, it's going to lose its lien possession. Okay, so you have to revive the judgment every 5 years. Okay, the judgment doesn't necessarily go away, but you have to revive it every 5 years. Okay, so just think of it that way. Okay, so you don't have to argue why it should be around. So every 5 years, you have to revive the judgment. The way you do that is you go to municipal court and you say, you got a judgment, I'd like to revive it. Okay, it's a very simple filing to do. Okay, so that's the rule. 5 years.
Thank you.
Hi, I have another question. Earlier you mentioned this lead safe certificate. So basically the question was, you see some cases like landlord didn't ask, or tenants should put it this way, tenant refused to sign that lead safe certificate, and then you said currently the court didn't really enforce that, meaning the landlord would not lose the case because the tenant didn't sign that lead safe certificate.
Yeah, the landlord has to show that they tried to get the tenant to sign. Okay, so the way you do that is you send a letter to the tenant requesting them to sign it, and you keep a record of that letter. Okay, and if the tenant refuses to sign, you send another letter telling them they must sign. And you can even put in a term of the lease that they can't move in until they sign the certificate. That would be the smart thing to do. Have that certificate. But yeah, if they don't sign it, you just need a record that you delivered it to them, and that's all we usually have. But if you have an additional record that says you tried to get them to sign it, that would be great too. But you definitely have to show that you delivered it, okay? And you just have to have that letter, okay? And the letter, showing that it's been mailed out to them, okay?
Okay. And are you aware if there are two versions of the lead safe certificate? Like one version, like in the middle, has that section, like a tenant needs to signature, like in that section.
Yeah, I'm seeing now it's more and more of them. All of them have the signatures for the tenants, but there's some that don't. And I'm not going to. I don't know why. I don't know why the inspectors even give out certs that don't have a signature spot. But it used to be very common. It's not as common. If you have a lead inspector who's doing that, maybe you can ask him politely. Just say, why don't you check that out? And maybe you'll get a new certificate next time. Okay. Because it is frustrating, but it's just the way it is.
Yeah, I tried to research on the government website. I tried to locate that version that without tenant's signature section. I couldn't find any. Actually, I've been working with an attorney, David Dannenberg, and then he asked me to research on this area.
I know he's a nice guy. David I've worked with him for many years. His family is, I think, 4th generation lawyer or something. Amazing.
Yeah. Yes.
I know Mr. Dennenberg very well. He's a very good man.
Yeah. So I'll try. He asked me because he seems like lost the case. The case brought to the Superior Court. I don't remember. He was representing the tenant or the landlord. It's about the lead issue, just that particular form. So I suspect, because I did research on the government website, couldn't find that version. I suspect someone could have just.
Feel free to call my office because I'm definitely curious about your weekly leases, and also you can talk to me. I can go for this, show you the statute and stuff like that, and give my regards to Mr. Dennenberg as well.
Oh, thank you.
Yeah, you know why? He's suing my client. What a
okay, I know you guys are working together. Okay, I don't want to get him in trouble or get myself in trouble.
No, he's not a bad man. He's a good man. He's a great man. I sue his clients too. We sue each other all the time. I'm curious this lease you have, but I don't want to talk about it now. But
yeah, I'll reach out to you offline. Yeah,
I appreciate that.
Thank you.
This is the last question I see in the notes section from Amanda. How do you file judgment?
All right, so Amanda, you win your what happens is you go to court, tenant doesn't show up, you get a default judgment. Okay, you get a default judgment, and the tenant has about 10 days to appeal it. Okay, So boom, you got your judgment. Your judgment can have your judgment in landlord tenant has two parts. It's a judgment for possession, which means you can go to the Philadelphia sheriff after filing your writ of possession, your writ of alias, and paying the sheriff and do a lockout. That's for possession. But the judgment could also have a money part too, for money. And that money part just stays on the docket. One very important thing is that when a tenant pays you money, just tell your lawyer, because sometimes I get calls, it's like once a year, and a tenant, might pay some money, okay, but not all of it. And you really are supposed to reduce the judgment amount when that happens, okay? So remember, if you do somehow get paid, first of all, congratulations, because it doesn't happen that much. But if you do get paid, remember to take the judgment off the docket or to at least reduce it, okay? And because you can't just leave the judgment there once you've been paid, okay? It's just hard to remember though, but yeah. Yeah, it doesn't happen very often, but okay. So the other issue, I apologize. The other issue is you win your trial, and boom, you get your judgment. And yeah, so those are the two ways you get your judgment. They don't show up or you win a trial. Or, sorry, you do a judgment by agreement, whereby you and the parties come to a terms and you have a judgment by agreement. So there's three ways. Default, they don't show up. Judgment by agreement, where you and the tenant make it a deal, and you get judgment from a trial, okay? The best judgments are judgments by agreement because it's very hard to appeal them, and you are allowed to garnish wages. In Pennsylvania, you can only garnish wages if you're the government for taxes, child support, and a landlord-tenant judgment by agreement. And I don't like this. I think that's amazing because I really don't know why politicians did that. I don't know why I know why politicians, they're the government. They'll garnish wages for taxes. That makes sense. Government wants to take all your money. I get the garnishing for child support because children are so important and stuff. But it's interesting that the government chose a landlord-tenant, that we can garnish the wages of tenants. I think that's really interesting. I don't know why I think that's really, really fascinating. Anyway, so did I answer your question?
Does anybody else have any questions for John this time? I don't have anything coming out from my WeChat private messengers.
Great.
Well, if not, we need to adjourn this meeting. And John, thank you so much for your help for this seminar.
Great.
The information you presented to us is super, super valuable. Save us a lot of time. And I hope that you can continue providing us, in the future seminars, some more information on the legal matters.
Absolutely. Thank you for the opportunity to speak to everybody. I hope everybody has a great weekend. And I think we'll definitely we'll give out more information about the Landlord Association, definitely coming up in the next month or so.
Great. John, thank you so much.
No problem.
Everybody, have a great weekend.
Thank you.
Thank you.
you.
All right. Bye-bye.